Thank you, everybody that's joining us. And for those of you that aren't able to, you can catch the recording. So we're going to get started. Jesse Rember and myself, Kimberly Diaz, will do introductions in a moment. So this is estate planning every adult 50 years and over should have in place. As I mentioned, I'm Kimberly Diaz. I'm a registered nurse of 27 years, and I really focus on helping the sandwich generation navigate dementia and the challenges of aging parents before a crisis happens. I'm also a death doula and a geriatric care manager, and working with Jesse currently to get my estate planning and my end-of-life planning in order. So Jesse, you want to introduce yourself?
Sure. I'm Jesse Rember. I practice here in Arvada, Colorado, and my work specializes with small estates. I work with people with estates under $5 to $7 million. My plans are custom designed. I like really digging in and working with someone on getting a plan that really suits their individual needs. I also participate in a lot of areas in the Bar Association, but especially in the area of medical powers of attorney and living will. That's where I really dig in and love doing research. So it's been really fun to do collaborations with Kimberly because she gets the other side of it. I mean, I like the statutes and I like the reading work, but Kimberly fills in what really happens out in the field. And she's a tremendous resource.
Awesome. All right, so we'll get started. So why this conversation matters. 70% of people want to die at home. However, only 50% of people actually have their documents in place. So we've got a mismatch there. And unfortunately, most people, if you don't have something in place, will die in a hospital surrounded by strangers and by machines. And end-of-life planning is something that 100% of families are affected by. This isn't about dying, it's about protecting your family from chaos and helping them honor your wishes. So the cost of waiting, what happens without a plan? These are things that I've seen in person and here in Colorado, as well as when I was practicing in California and in Illinois. Conflicts between loved ones, adult children arguing at the bedside over medical decisions because each of them believes they know what mom or dad wanted, yet there's nothing written down. Decisions made in crisis. When I worked trauma, it was very common. Maybe a younger person was involved in an accident in their 20s or even younger, as well as older people. But extreme stress, so the frontal lobe turns off. You can't, you've got that deer in the headlight look, and you're having to make life or death situations for your loved one, and you've got no directions to follow. And then there's the lasting trauma that goes along with that. For years, families carry this guilt, wondering if they did the right thing because nobody ever wrote it down. And again, I've sat with many families in the ICU and in the ER saying, I wish I knew what they wanted. And this is your opportunity to do that. So understanding the full picture, end-of-life planning versus estate planning. Sorry, my dog's barging in. Estate planning is the legal side of it. So the wills, the trust, the asset distribution, the beneficiaries, that's what Jesse's going to talk about. My piece as a death doula and an end-of-life specialist is the end-of-life planning. So asking those medical questions and preferences, quality of life issues, care, location, environment, really touching on the spiritual, emotional, and legacy support that people need and want. So it protects your estate planning, protects your assets, end-of-life planning protects your humanity. So a lot of people ask, what is a death doula? I've been in this space for 17 years. It's becoming something kind of trendy. It kind of seems like everybody wants to be a death doula. But what is it? So similar to a birth doula where they support the beginning of life with presence and guidance and love, a death doula, I support you in that final chapter. So the role isn't about medicine, it's about meaning. So for different families, this can look a little bit different. However, supporting that emotional and spiritual piece of people that we all have, it's not religious, it's spiritual. Family conversations, facilitating those conversations that family hasn't had. I recently had a very good friend who lost her husband at 58 years old, and I was called by the sister to get back to Chicago to help them, and I got there, and he died within 10 days of me being there, but he was sick for 9 months from cancer, and they had never talked about what if he didn't make it. Those conversations were never had. So I was able to facilitate, talk with him. He said she won't talk to me about it. Go then talk to her, got them to speak to one another, get these things written down. I spoke to the children, letting them know that dad may not make it through this. What are some of the things that you want to talk with him about? So that's some of the stuff that I can do as a death doula. But had some of this stuff been done ahead of time, it would have, allowed that time to be for other things. But I am grateful that I was able to be there for them during this time. Legacy and meaning making. Some people, helping capture stories. Sometimes we put that in email. Sometimes we do recordings of voices. Just these messages that last forever. We did a lot of this in hospice with legacy planning, which is just a gift that keeps on giving. Vigil planning, so support before, during, and after the moment of death. So this is one of the greatest gifts you can give your family. It gives them clarity. They know exactly what you wanted. No guessing, no conflict, no regret. The peace of mind so that they can grieve freely without the burden of impossible decisions. Reduce guilt. When your wishes are documented, families are free from the haunting question of, did they do the right thing? And honoring your life. A plan allows your family to celebrate who you were, not manage a crisis. So again, the greatest gift you can give your family is not leaving them guessing. And listen, I know these conversations are hard to have. Nobody wants to have them. My husband and I, like as I mentioned in the beginning, are going through this right now. I'm very vocal about what I want, so he's known that, but we hadn't written it down. I didn't know what he wanted, but we made an appointment with Jesse, and that for me then allowed me to get him to sit down and write these things down, because we've got an appointment with Jesse. We need to have this stuff written down before we go in there. So that was my way of getting him to sit down and talk with me about it. I'm 56, he's 61. You think we're too young. I just had my second classmate die this past weekend. Another one died last month. We're 56 years old. We shouldn't be dying this young, but it happens. So when should you start planning? Obviously, the best time is before life forces your hand to. But there are natural moments that can signal that. Age 50 is one of those triggers that you should start having these conversations, start getting things written down. Retirement, now that's another time of major financial and lifestyle changes. So call for a comprehensive review of the plan. My husband and I are getting right into both of those. We're talking about retirement as well, so we're kind of between 1 and 2. Chronic illness diagnosis. A diagnosis makes planning urgent and much more meaningful. Cognitive changes. I'm a dementia consultant, so this piece is near and dear to my heart. Oftentimes you've got just a very short window of time when your loved one might have the capacity to make their decisions and get them into writing. So sometimes families need to act, usually they need to act faster than they think they need to. And Jesse and I have had some shared clients where, boy, that window, we just nailed it right before it would have been too late. Loss of a spouse. That's another time to really reflect and ensure your own plan reflects your current reality. And then now I'm going to hand it over to Jesse. I can't hear you. Oh, you're muted.
I'm going to go ahead and share my screen so that
Yep.
I can move
Okay. Yep.
move the slides is what I'm trying to say.
Yep, you should be able to do yours now.
Okay. All right. Setting my timer because I could talk about this all night long. So I'm going to piggyback on what Kimberly just said about conversations and timing. This is my mother-in-law. She passed 13 years ago. And up until the time she passed, we never had conversations with her. We knew that she had hired an attorney to do her estate plan, but we didn't know what kind of plan she had in place. My husband only knew that he was her agent and her personal representative. So we got through the first part of her estate. So she got sick. She got what we thought was food poisoning, and I don't know, several days later, ended up in hospice, which was not at all what we were expecting. So there wasn't time for these conversations. And I can remember thinking as a first-year law student, and I was required to take estate planning. I thought this is never going to apply to me, right? Because I'm not going to die, at least not anytime soon. And then before I knew it, I was in front of my mother-in-law and we were losing her. And there is so much we could have captured and so much we could have been so much more aware of had we actually had these conversations with her. But she didn't want to talk about it. And we for sure didn't want to talk about it. But it's because of her probate that I got into estate planning. Her end of life things were very, very organized. And we thought, great, this is great. She has great planning. And then we got to her will and realized her attorney did not do a very good job for her on the estate plan. And I thought I could do better than that. And I haven't taken estate planning in 35 years. Anyway, I ended up in estate planning, and I'm super glad to be here because I do better plans than my mother-in-law had, and I'm pretty proud of that. So I just want to put two things out there. Estate planning is a state matter. It is entirely based on your state's laws. Unless you hit that $15 million mark, and then there are some IRS rules and some other federal laws that come into play. If you don't have $15 million per person, you don't have to worry about that. If you are outside of Colorado and looking at this, use what I talk about here as talking points to talk to your attorney and to research laws in your own state. The second one is I have a lot of clients who like to use AI before they get to me. And the problem with AI is there's a lot of nuance in estate planning, and much of it depends on exactly where you are in your life, what you have, what you value, and what you want. And AI is not going to be able to help you with that. They can produce very sterile documents, but they can't really capture what you want for your end of life wishes or for your estate. So the third thing
Jesse,
I wanted.
You're not moving the slides forward, Jesse, just so you know.
Oh, they're moving forward on my side. Okay. Should I just do it like this? Is that better?
I think that's
Can
fine.
you-
Yeah, they just weren't moving forward for us. I'm not sure. We were stuck on the first one the whole time you were talking, so I don't know.
Okay. All right, we'll try this again. Is to choose your attorney wisely. You're the buyer in this relationship. And if you call an attorney for an exploratory call and they just rub you the wrong way, your entire estate plan, you're going to feel rubs you the wrong way. And you're never going to feel like you were served. You should interview your attorney, not just for their knowledge, but for whether they're a good fit for you or not. If they're not paying attention to you, if they don't respond to your questions, if they don't seem to want to take any time with you, that's probably not your best choice. But interview your attorneys and make sure you're getting somebody that you can communicate with. Did that move forward?
It did not.
No.
Okay. We'll do it this way. Okay. So we have 3 phases of life. We have our today person, we have our future person, and then we have the in between. So when we're estate planning, we want to think in terms of those 3 timeframes. For today, what you need are powers of attorney. Those are documents that govern how your medical and financial decisions are going to be made should you not be able to make them yourself or just not want to for whatever the reason. The second part is the future, and that's your will or your trust or your will trust combination. And that is going to largely be something you negotiate with your attorney. We're going to talk more about wills and trusts in a few minutes. But the in between is that living will, and those are your end of life decisions. Your living will is going to kick in when you are no longer able to make your own decisions right around your end of life. So it's focused on whether you want artificial nutrition and hydration, whether you're going to be given life sustaining procedures. And those are big decisions. And that's where the people that are caring for you are going to get stuck. Because if they don't know what you have in mind for your end of life, they don't know what decisions you would have made if you were able to. And we'll come back to that a little bit later. So for your estate planning, you can have a will or you can have a will trust combination. You can, the living will is not related to the will. The living will is just your end of life decisions. It's neither living nor a will. We don't know why it's called that. You get a medical power of attorney to govern your medical decisions and a financial power of attorney to govern your financial decisions. And we'll get into that more in a minute. So let's talk about the will process for a second. A lot of people come into my office and they absolutely want to avoid probate at all costs and insist that a trust is the way to go. And I can tell you that with a trust, you are just as likely to end up in probate as if you didn't have one. And we'll talk more about why that is later. But wills are really handy. There are some really nice features about them. The first is that they spring to life after your death. Once you die, your power of attorney forms, die with you, and your will takes over. Your will is an instruction manual for your personal representative, who is the person who's responsible for winding up your estate. In Colorado, the threshold for a probate is $88,000. There are 2 types of assets, probate and non-probate. Non-probatable assets are things like your securities, investments, retirement accounts, life insurance. These things all pass by contract. They're not part of your probatable estate. So what is probatable is your cash, your house, your cars, things like that. But if you've removed your house from your estate, it may be very likely that you are under that $88,000 threshold and you may not need probate at all. We have an affidavit your personal representative can use to move things to the people they're supposed to go to. So it's a really handy little benchmark to keep your eye on. That amount does change every year. There's also a very short creditor claim period. They get a certain number of days after notice is filed that there's been a death and a probate opened. Once that creditor claim period is closed, no more creditors can come forward to claim from your estate. It's really on your creditor to be aware of what's happening. You have a very limited requirement for specifically notifying creditors. It's really cheap to do a probate. It's $149. Probate in Colorado is intended to be done by individuals. And so sometimes attorneys have trouble filling out the forms because they've taken out a lot of the legal language so that non-lawyers can understand them. But then we don't know what those things mean, so we have to call the clerk and find out. But it is a pretty basic plan. All the information is in the district court, whatever county you're based in. Estate plans without a trust are vastly cheaper than estate plans with a trust. And they're very easy to amend during your lifetime. It's a very fluid document. You can amend it at any time. You can revoke it at any time. It's just a very flexible document for you to have. Trusts, on the other hand, are handy for the right person. So they come to life either during your life as a revocable trust, or after you die, a revocable trust will become irrevocable. Or you can have an irrevocable trust, and they are just what they say they are. Trusts that are revocable can be changed and modified at any time. Irrevocable trusts are what they are on the day they become irrevocable, and you no longer can change them. These are private documents, so if you don't want to open a probate and make your will public or accessible to the public, then a trust might be the way for you to go. And there are some clients that I have where privacy is a real issue for them. They are perfect for somebody who has a beneficiary or an heir who is receiving Social Security disability or Social Security in general. Any of the disabilities that come down from the state and federal level, their income earning is capped at a certain amount of money, usually somewhere around $2,000. So an influx of money from an inheritance would kick them over that level and would kick them out of that program that they qualify for. So using a trust to trickle the money instead of causing a flood helps people maintain their benefits, but also have access to that money to the extent that they can. There are some families that are just complex. They either have people in their family with specific issues, drug addiction, alcoholism, or just really bad blood between some of the siblings, or maybe some of the family members of the parents. And there are also blended families where you have his, hers, and theirs children, where you really need to be specific about tying up money to make sure that if you die first, your kids are taken care of. And that's another great place to use a trust. But most people come in and they say, well, I don't want to pay taxes, and I don't want the state to get my money, and I don't want any problems with probate. Like, I don't want my creditors coming after all my assets. And the truth is that a trust is never going to do that for you. Unless you have an irrevocable trust, which most people, it's not a good idea for them. There are no tax advantages. There isn't the creditor time period for a trust is very long compared to a probate. So you are susceptible to claims for a much longer period of time. And the administration is complex, and quite honestly, because I deal with small estates, I get a lot of clients who really just don't have the sophistication to be able to manage a trust. They require constant care and keeping. They require annual tax returns. You need to do tax returns if you make distributions. Like you have to be willing to stay on top of what's required to administer a trust. It also doesn't necessarily avoid probate. If the classic example is people come in and they get trusts and then they don't fund them. So what happens is you die and you have this document, but your house is still in your name. So now we have to open probate to move your house into the trust. So it's complicated. We pretty much have to do what we would have to do if you didn't have a trust. So when you're asking for a trust, know what you're asking for. There's a lot of social media right now that's out there telling people that they must have a trust or they're going to be an administrative nightmare. And it's just not true, at least not in Colorado. There are states where it's more appropriate for more people to have them. So when someone comes in and they ask me for a trust, I want to know if they own property out of state, we're talking about a trust. Complex family relationships, yes. Part of a blended family, possibly. Single parent with young children, probably. One or more beneficiaries who receive SSI or SSDI, yes, absolutely. And if there's a concern about capacity, like Kimberly said, there's a short line sometimes between the diagnosis of potential incapacity and the actual incapacity, and it takes a while to get a trust up and running. So this is not something that you want to wait to do if you think capacity is going to be a problem. So let's skip back now to the documents that you need while you're alive. There are two types of powers of attorney. They do the same thing, pretty much. You elect your agents. They're powerful tools. They allow your agent to carry on your business and make your decisions for you, should you be unwilling or unable to. Often, when people are unwilling is when there's a secondary trauma happening. Someone's just been diagnosed with cancer. Someone's just lost a loved one, and they just don't have the mental space to deal with their bills too. They're effective once they're signed and notarized, and they're very easy to revoke. Most of them can be revoked by destroying them. Not what I would recommend, but you can do it that way if you want to. So the first thing we're going to talk about is the general durable power of attorney. This is your financial power of attorney. And the questions you really need to hone in are who is it that you trust with your money? Because you're essentially turning your money over to this person once they take over as agent. Do you want to limit their authority in any way? Or do you want to limit which agents have access to which authority? If you have investments, do you want them to be able to change your beneficiaries? Do you want them to be able to buy and sell your mutual funds? If you own a business, should they be winding your business down? Should they have access to your business banking account? And if you own a trust, are you going to extend your privileges as the trustee to your agent in some respect? Because that's a little unusual, but we can build in some of those functions. This is kind of where I want to sit for a minute. The medical durable power of attorney is probably the most undervalued document you're ever going to fill out. This is where the rubber meets the road, because this is where you're sitting in a hospital bed, unable to make your own decisions, really unable to even quite comprehend what's happening to you. And you are relying on someone to help you with those health decisions. So a lot of people say, well, I have so-and-so in my family who is a doctor or who is a nurse. That's maybe not the person who should be your agent. The person who should be your agent is someone who understands what you would do if you were in making these decisions by yourself. Who's actually going to carry out the wishes you want them to? Not what by medical standards, but by your standards. Medical standards are going to be upheld by the people who are caring for you. Who's going to be advocating for you? Your agent. So talking to them about whether they're up for the job, making sure that they understand what those wishes are by memorializing them in the living will and the medical power of attorney, making sure they know what your anatomical gift requests are. And anatomical gifts can be limited and expanded any way that you want. Remember that this does come with a HIPAA release, so they are going to have access to your medical records. So if you would like to limit access to your medical records in some way, this is a really good place to do it. Living wills and medical power of attorney kind of go hand in hand. One of the responsibilities of your agent is to advocate for what you have listed in your living will. So you have a couple, you're going to be working in two separate areas mainly. One is if you are diagnosed with a terminal condition, and the other is a diagnosis of persistent vegetative state. So you have to be determined to be in that condition by two independent physicians. So it's not something that is just, we think you're in a persistent vegetative state. You actually have to be in that persistent vegetative state. You also have to be unable to make your own decisions. You will be making your own decisions as long as you can. Under each of those, you'll be choosing whether you want life-sustaining procedures, which is usually a ventilator, but it could be something else, and whether you're going to get artificial nutrition and hydration. Most recently, we've added a section for neurocognitive illness. Not all lawyers use that. I like it because that's what a lot of my clients are very, very concerned about. And there you're really focusing on whether you want artificial nutrition and hydration, because there is a fine line between force feeding and feeding. And we would like to know what that line is for you. So to fill out your medical documents, you would need a DNR, a MOST, and possibly a BOST, which is your behavioral health. These are not legal documents. You get these from your medical team, and all you have to do is ask for them. Your doctor will have a discussion with you and then sign the form. These are things that are kept at the hospital. Your legal documents, your medical power of attorney, and your living will, you need to bring to the hospital to be put into your file. As you're building your estate plan, there are some other classes of professionals that can really help you. Accountants, investment advisors, and insurance agents are kind of your go-to. I will often direct you to those people for specific questions. It's nice if you've chosen your own, because again, not everybody works well with everybody. But if you don't have them, I'm happy to make recommendations for my people to make some calls. Did I draft this slide? I don't remember this slide. Okay, hold on. Yeah, so there are some states where probate is just onerous, and if you don't have a trust, you're going to be in trouble. Colorado is not one of them. So before you jump to deciding what you want with your estate plan, take a look at what your state laws are with regard to probate. And even the rules about living wills and medical and financial powers of attorney are different. And I think we've mostly answered these questions. So if you all have these questions, let me know.
I think people can at this point, if you'd like, they can come on and ask some questions about it if there's specific things. And then this is kind of like those last two slides are really just go to the one before you were just on, Jesse. There you go.
Yeah.
So there's where, there's the recommendations on what people could do. And I don't know if you want to take that back over, Kimberly, and talk about it. But if there's questions, let people ask those if they want to. I have a question, but let's see what everybody else has. You can either raise your hand or you can just unmute yourself and ask whatever you prefer if you have one. So I was going to ask Jesse, if you've already gone through and had an attorney, the reason I'm asking is because I take care of my cousin. I'm the medical power of attorney for my cousin in South Dakota who's got dementia. And we did this quite a few years ago when she was still, was not in active dementia. And we've done everything that the lawyer recommended, including put my name on the house and on her car, and I'm a signer on her bank account. And then she made me the beneficiary of all of her retirement stuff. And so I thought that would be the reason to avoid probate. But from what you're saying, that medical power of attorney, the financial power of attorney stuff goes away as soon as she passes. So does that mean it's still possibly going to be in probate, even though I've done all those other things?
No, not necessarily, but you're talking about a state that I'm not licensed in, so I don't really know. But if we were in Colorado, again, in Colorado, we have that it's 88,000 for 2026. If your assets, if your probatable assets are under $88,000, probate's not necessary. But I tell clients all the time, people will say, lots of my clients will say, well, I don't really own anything. Well, then the purpose of the will is to designate the personal representative, because somebody needs to step up and take responsibility for these danglers, the car, the furniture. Like there's always dangling pieces.
Yeah.
So at a minimum, you want the will to designate the personal representative so that somebody knows, the person who is going to step in to wind up your estate knows who they are and what they have to do.
Yes.
I don't know what the rules are in South Dakota, but I would definitely look into that.
Okay. So if her house and car and everything is worth more than 80, like I'll just say for the Colorado
Yeah.
I'll look into South Dakota. But if it's over $88,000, that means it'll still wind up in probate regardless of what we've done, even if I'm on the house note and all that stuff.
Well, if you're on the house, it depends on how you're taking title.
Oh, I
That's
see.
not something I ever recommend for my clients, but if you are on the house, make sure that it's joint tenancy, because if joint tenancy means that the surviving title holder
Yeah,
takes 100%. If it's tenants in common, at least in Colorado, it means that the surviving person retains their 50% and the other 50% goes downward in the family, goes
gotcha.
to children, their children, siblings. There's usually a list in the statute.
Gotcha. That makes sense. I think she has first right of refusal as far as living there, but once she passes,
Mhm.
I think it goes to me. But either way, that makes sense. I was just curious about that. So thank you for answering that question.
Yeah.
Yeah, and Michelle, I was going to say, I had to make sure that Cara helped me with to find out how our title was, or how our deed was written as well, because I wanted to make sure if something happened to me, that my half of the house wasn't going to go to my kids, and then have my
Mhm.
kids fighting with my husband over the house.
Right. Which makes sense.
Yeah, yeah. So, yeah, I was just going to touch base on these. Does anybody else have any questions? The one thing that I did want to mention, though, that comes up quite a bit is maybe feeling like you have to have your child be the power of attorney, or you
Right.
have to have somebody specific. And I'm telling you, you need to follow your gut and go with who you think is going to be your best representative. My husband and I, both of our powers of attorney outside of each other, are not family members. They are friends that we've had for a long time that we, explicitly trust to take on this task. I have 3 children. I have other family members, but that doesn't necessarily mean those people are going to be looking out for your best interest or be able to follow what you want. So
And there are professionals who do this.
yeah.
Kimberly and I have somebody in our network who acts as my medical agent for my clients who just don't have anybody. Some of my very senior clients, they have no family, they have nobody, they don't have close friends. Um, they may have caregivers, but those caregivers don't necessarily want to be their agent. So we have a friend who that is what she does. She is the professional medical agent for a lot of my clients. And there are lots of financial people who do it. Often investment advisors will act in that role, or there are a lot of professional financial fiduciaries, but you can find them for medical as well.
Yeah. I was going to say, I also do that for clients. I have a couple that he's got children, but he's been estranged for them for decades. He doesn't even know where they are. And so they don't have anybody. They're giving all their money to charity. So I'm their medical power of attorney. And
Mhm.
another attorney that we work with is their financial power of attorney. So there definitely are professionals out there that can take this over. I see Linda has a question mainly around how to do the most to make one's assets last for as long as possible. My husband and I are professional musicians, so our estate is not above Jesse's threshold. We also don't have children.
That's a great question, and that's something that would be a lengthy conversation between you and me. Um, and that's where I would say to you, let's look at the potential for putting insurance in place that might help you cover some of your expenses, especially with younger people. There's a lot that insurance can do: term policies, life policies. There are now life policies that are part long-term care. So insurance can come in and fill in a lot of gaps. But also working with an investment advisor to make sure that you're maximizing your investments and that your investments are appropriate for your age group. Especially my clients who are self-investors started investing at 30 and they're investing today at 70 and 80 the way they invested at 30. And it's that's probably not okay. When the market tanks, your money's gone. So, yeah, I mean, you want to be in touch with an investment advisor who can help you kind of right size your investments and kind of help you decide when it's time to start taking some of that money and what the highest use for that money is once you receive it.
Right, right.
Retirement is always tricky. I don't even want to get into that because there's so many rules. But talk to your investment advisor, your retirement advisor, and sit down and talk to an insurance agent. They're pretty smart.
Yeah,
I
I
married one.
agree.
I should know.
Because that's what Nelson and I are doing now too, figuring out, okay, at what point do you pull out from which investment? Do you
Yeah.
do the IRA? Do you do the 401k? Do you do, so you need to figure all those things out.
And how they play together. Sometimes we think of them as distinct areas, but once you get into retirement, those things start to play together. And you need to figure out which investments to liquidate first, how much of that you want to take out, what's your most strategic move. And a good accountant, investment advisor, and insurance agent can really help you maximize your dollars.
Yeah. And Jesse and I both know some as well. So if you need a referral or something like that.
Jesse, will you go to that last slide just so they can see your contact info? Thank you.
Yeah.
Yeah. So if you want to reach out to Jesse or I, our contact information is here. And if you have any other questions, we're here and able to answer those.
I was going to say too, Kimberly, your last comment and what you guys were both just talking about, even, family members that I have that are in very, very healthy, they didn't even plan on living as long as they were going to live, kind of thing.
Yep.
So they've had to look at their investments again to make sure that they've got money to last for as long as they're going to last. You know what I mean? So I think they're almost 80 years old and are so healthy that, they may last another 10, 15, 20 years. Who knows?
Yeah. Yeah. Yeah, and I mean, that's what I hear from seniors all the time because I help with placement and end of life decisions is I didn't expect to live this long, so I don't have enough money, or I didn't think I was going to get sick. Well, here we are, you're 85 now, and now what? So trying to help them figure out where do we go from here? So all of these things. So Linda asked if you're licensed in New Mexico, Jesse.
I am not, but I can help you find somebody.
Yeah. And then Cara, who's on here, another thing we always talk about too is knowing your numbers. Know what, taking the time, getting all that together, know how much money you have, know your assets. All of this becomes really important when you're making these decisions.
Yeah.
All right. Well, if we don't have any more questions, this is going to be on my YouTube channel, Michelle?
That's correct. And I'll send everybody a link to it that was registered for the seminar or the webinar. I will send everybody a link to it.
All right. And then she'll also send those that were here a link to the booklet that you can fill out about what your wishes are. My husband and I got him to sit down on a couple of weekends and I just started asking him the questions. We use this exact book we're sending you. It's from a company called Compassion and Choices. I volunteer with them here in Colorado, and it takes you through all the questions. You write everything out, and you can bring that to your attorney to help them fill out the documents for you. So this is a very useful tool, and it's something that we're going to provide you the link for as well.
And it really asks some really super questions. Like Kimberly brought me hers, and I was able to print out the pages that she filled in. And now I'm going to be putting that into her living will and or medical power of attorney, depending where it goes. So the person who's going to take over as her agent has an absolute roadmap for what she does and does not want. And some of those questions can touch on, especially if you're going to supplement with the 5 wishes documents, do you want candles in your room? Do you want soft music playing? Do you want to be around your pets as often as possible? Get down to some of those things. And people often think there isn't room for that in estate planning. In my mind, that's what the medical power of attorney and the living will are all about. it's a brain dump of everything you want for your end of life. You may not be given all those things because it's not appropriate where you are, but you'll be given as many as you can, and that's sometimes good enough.
Yeah, yeah, absolutely. And there's a whole section there too on dementia, which is really near and dear to my heart. And, you know, that to the best of our ability right now, you know, what they can ask for ahead of time is limited, but at least that lays down the foundation pretty clearly.
Dementia is an area too that's developing very quickly. It's still in process. Unlike a lot of estate planning, which has been around for a long time, this is kind of a new thing for us. And so we really are looking to our clients to bring us whatever information they can, because lawyers understand the law, they don't necessarily understand the disorder. And so the more information a client can pass along about disorders that they have, the better off we are and the better planning we can do for that specific client.
Yeah. And I know there was a piece about organ donation, but I've got a movement disorder, so I'm going to donate my brain tissue to Harvard for research. So Jesse's adding that in there too. And I got my contact cards and that information. So Linda said in her state has the option to choose when to die when you're terminally ill. Yeah, we have medical aid in dying here also, Linda, but unfortunately you have to have capacity when you're making that final decision. So that still doesn't cover people that have dementia unless they would want to end their lives very early on in their journey, which is not the case. So I still feel like there's room to improve that. We do have voluntarily stopping eating and drinking. That's legal in all 50 states, but they'd also have to have the capacity to stop eating and drinking and understand that.
Right.
So it gets tricky. You can sign though. Isn't there something you can sign ahead of time? Oh, like I have, that I don't want to be force fed. But you also then have to make sure you're in a community that's going to uphold those wishes, because some communities that are like Catholic based and things like that, they won't allow for you to stop eating and drinking. So there's a lot of moving parts when it comes to that. But medical aid in dying is also legal here in Colorado, thankfully.
Yeah, and there are a lot of misconceptions about what it is and what it isn't. A lot of people think medical aid in dying means you get a pill and you go to sleep and you don't wake up. And that's not at all what the process is. It's very unpleasant, and you have to be able to administer the drug yourself. Yep. And that in and of itself, is a barrier for even people with capacity. They may not have the physical ability to do it. No one can help you with it. Your agent can't help you take it.
I'm actually doing a presentation on it tomorrow morning to CSA.
Yeah, it's a bit of a challenge. And when my clients come and say, I want to opt in for aid in dying, I say, first do the research and let me know if you still want to do it. And most of them say, I think I'd rather just not have life-sustaining procedures and not have artificial nutrition and hydration, because it's a very stressful process.
Well, and 30% of people that get the medication never even use it. So I think it's just kind of that peace of mind to know that you've got the option to end suffering if you so choose to, you know what I mean? So, But, all right. So if there's no other questions, you can get the replay on our YouTube channel. And thank you for joining us, and have a great week.
Yeah. Kimberly, thank you for hosting.